What does it mean for a civil lawsuit if your abuser has been convicted in criminal court? If you've experienced sexual abuse, you might be thinking about taking legal action in civil court. I'm Natalie Gerry, the principal lawyer and founder of Gerry Law. I help injured people, and in particular, sexual abuse survivors, get justice for what happened to them. You may not know that a civil action is even an option. Many survivors go to the police first, thinking that criminal court is the only path for redress for a sexual assault. But in civil court, we can also bring a lawsuit related to the sexual assault or sexual abuse. This is another way to hold the person who harmed you responsible and to ask for money, called damages, to help support your healing and to provide some compensation for what happened to you. If your abuser was already found guilty in criminal court, that can help your civil case in important ways. But the process is still complicated, it can still take time, and it may be emotionally difficult. Here's what you need to know. So first of all, criminal court versus civil court. Let's go through some of the differences. Criminal court is where the government charges someone with a crime. The focus here is on punishing the abuser. Civil court is where you, as the survivor, file a lawsuit. The focus is on getting financial compensation for the harm that you suffered. You can choose to go through the civil system even if there was already a criminal case. You can also file a civil case even if there was no criminal case, or if there was a criminal case and the abuser was found not guilty. If there was a conviction, so a guilty verdict or a guilty plea, there are some considerations. If your abuser pled guilty or was found guilty at criminal trial, that helps your civil case a lot. And this is because of a rule in Ontario law, so under an act called the Evidence Act, that states that if someone is convicted of a crime, it's assumed that they did what they were convicted of, even in a later civil lawsuit. So this rule means that you don't have to prove all over again that the abuse happened. You may be able to skip that step and move straight to showing how the abuse has harmed you and how much compensation you deserve. So in one of the cases that I was involved in prosecuting a civil sexual assault matter, the assailant had already been found guilty in criminal court. So we were able to bring partial summary judgment on that issue, and we successfully got partial summary judgment on the issue of liability. So you might be wondering, what is a partial summary judgment? This is a legal shortcut that can be taken in civil court. So it means that a judge can decide part of the case. So this would be deciding the part of the case about liability. So whether the abuser was legally liable, and this goes without a full trial of the issues. So what we can do is just put the conviction in front of the judge and say that our civil action rests on the same facts. And then it is quite likely, based on the existing law, that if your abuser was convicted in criminal court, then you will be able to ask the civil judge to find liability in the civil matter. If your abuser was convicted in criminal court, your lawyer might ask the judge to say, yes, this person is legally responsible. So that's what liable means for what they did. Then the judge might say, let's just deal with how much money the survivor should get. So this is damages. And these are two separate parts of a civil lawsuit. So first the liability, then damages. And with partial summary judgment, we can shortcut past having to prove liability and just get into damages. Not every case is clear-cut though, and judges only allow this shortcut in cases where there is no real question about what happened. So one other real-life example is in a case called Lambert and Lambert. In this case, a man pled guilty in criminal court to sexually abusing his daughters. Later, the daughters sued him in civil court. So although he had admitted guilt in criminal court, he tried to deny everything in civil court. The daughters asked the judge for partial summary judgment to stop him from doing that. And the judge agreed, saying that he couldn't deny something he had already admitted and already been found guilty. The judge also said that survivors should know as soon as possible that they don't have to fight all over again about what happened, and especially when it's already been decided in criminal court. So this is helpful for survivors. If there is that criminal conviction, usually the judge in a civil suit is willing to take that step and apply that sort of shortcut and find on liability. Some things to know if you're considering a civil lawsuit after a criminal conviction of your abuser. So first of all, the conviction can make your civil case easier. You might not have to prove that the abuse happened again. You might not need to answer painful questions about the abuse in court. The focus can then shift to us showing how the abuse affected your life and what support you need. Second thing to know is that you will still have to prove your damages. So even if the abuser's guilt is accepted and liability is found, you still must show how the abuse hurt you. So mentally, emotionally, physically, or financially, and sometimes all of the above. So that means showing medical records, therapy notes, and work history. The third thing to know is that not every case works out smoothly. So even with a conviction, the abuser might still try to fight your case in civil court. They might say that the facts are different from the criminal action, or they might try to explain the conviction in another way. Civil court judges allow this only in rare cases, but it is possible. The fourth thing to know is that it can still be stressful and triggering going through the civil process. Legal processes take time, sometimes years. There will usually be delays. Not everything goes smoothly. Sometimes the defendant can cause delays, or there are unforeseen things that cause delays, which can be frustrating. You should also know you might need to talk about painful parts of your past again. It's common to feel overwhelmed or re-traumatized, and this is normal, and your lawyer can help you access support like therapy to help you through the process. There are important documents that your lawyer will need. So if you're filing a civil case after a criminal conviction, your lawyer will usually require the certificate of conviction, which shows that there was a guilty verdict. They may need court transcripts from the criminal case, including what the judge said, what facts were agreed to, so if the abuser pled guilty, verdict, or reasons for that conviction. These documents help to show what the criminal court already decided, so the civil court doesn't have to repeat that work and decide it again. Some of the things that you and your lawyer will consider together before moving ahead with a partial summary judgment. So your lawyer might consider it or might not consider it, depending if the conviction doesn't fully match what you're claiming happened in the civil suit. They might also not consider or consider not bringing this partial summary judgment if some of the abuse wasn't included in the criminal charges, because then the judge might not feel comfortable in the civil matter finding liability for everything that's being alleged in the civil matter. They might also talk with your lawyer. They might decide not to bring the partial summary judgment if you want the court to hear about every part of what happened so that they understand the full impact. So that would be a decision you would make with your lawyer if you want to go through all those details about liability in your civil matter. Also, if you're asking for more serious damages like punitive damages and you need to explain the full story, then you may consider not bringing the partial summary. Sometimes keeping the full story in court, even if it takes longer, is important for getting justice and the full compensation that you deserve. So you might be wondering if the abuse happened in an institutional setting, like in a church or related to a church or a school, what happens with those other people or institutions involved? If you're also suing an institution like a school, church, or sports club, the conviction only helps with the person who was convicted. So you still have to prove that the organization was also responsible. So this would be for something like failing to protect you or for covering things up. So the bottom line is a conviction helps, but it's not everything. If the person who abused you was convicted in criminal court, that can make your civil lawsuit simpler and stronger, but it won't remove all of the challenges. You still need to prove how the abuse has affected you, and there will still be legal steps to go through. At Gerry Law, we help survivors navigate this process with honesty and care, and we'll tell you what to expect and what your options are and how to prepare, and we'll give you a realistic outlook on what could potentially happen in your case. But just keep in mind, you don't have to go through this all alone, and you deserve to know all of the information before you decide what to do next. If you want to discuss your matter, please contact me at the information below for a no obligation consult.